The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The first case is State v. Taylor. We'll hear from the appellant.
Good morning, Mr. Chief Justice, and may it please the court. Nick Broad for the state. I'd like to reserve 5 minutes for rebuttal. The state's interest in defending public officials against threats of unlawful violence has perhaps never been more compelling. The appendix to our reply brief provides a stark illustration. In that appendix, we have collected just a sample of recent threats of violence against everyone from poll workers to public health officials to federal and state judges. But you don't have to look any farther than the facts of this case to see the real harm that true threats cause to individuals, to communities, and to the rule of law. The defendant here made statements that, taken together and in context, amounted to a threat to kill the Macon County District Attorney. The defendant backed up this death threat with boasts about access to firearms and a willingness to defy law enforcement. He even admitted that his statements were threats. The defendant's words mattered because they caused fear. The SBI investigated, the security at the courthouse where the district attorney worked increased. The defendant's words mattered because they caused disruption. The district attorney changed her daily routes. She took down an online video that identified her house, and she testified that she, quote, couldn't go anywhere alone, unquote, in the courthouse where she worked. And the defendant's words mattered because they didn't just threaten the district attorney. They threatened the rule of law. The defendant threatened to kill the district attorney for exercising her constitutionally recognized role of representing the state in criminal actions. In other words, the defendant threatened to take the law into his own hands. The First Amendment categorically does not protect speech of that kind. Yet the decision below puts an anvil on the scale for individuals charged with making threats of unlawful violence. The court's sweeping decision should be reversed for 3 main reasons. First, the Court of Appeals erred in how it applied the doctrine of independent review. Second, the Court of Appeals erred in holding that the state must prove a defendant's subjective intent to threaten. And third, the Court of Appeals erred in holding that there was insufficient evidence to convict the defendant of threatening a public official under the relevant standards. There's a lot going on in this case, so I thought it might be...
Mr. Broad, just to make sure that I understand the landscape before you go any further, you do not disagree, I take it, with the part of the Court of Appeals decision that would hold that the defendant was entitled to a new trial for instructional error.
That's correct, Your Honor. We concede that there was an instructional error in this case, that the jury needed to have an instruction on the definition of a true threat, and we have not argued that that instructional error was harmless beyond a reasonable doubt. So as this case comes to the court, the question here is between remanding for a new trial so that the state can retry the defendant before a properly instructed jury, or whether the defendant should be acquitted. That's the key question here. We are not asking the court to affirm the conviction. As Your Honor mentioned, the Court of Appeals did hold that there was an instructional error, but the court went on to also hold that the evidence was insufficient to convict the defendant in light of the First Amendment true threats doctrine. And that's why we're here, because the Court of Appeals remanded for entry of a judgment of acquittal rather than merely remanding for a new trial before a properly instructed jury. As I was mentioning earlier, I think there is a lot going on in this case, and it might be helpful for me to ground the discussion in the facts here, and then move on to some of the broader First Amendment issues, if that's all right. This case starts, of course, with a series of Facebook posts that the defendant wrote between the hours of 5 and 6 p.m. on the night of August 24th, 2016. His posts were triggered by his anger and frustration with the Macon County District Attorney, and in particular, her decision not to bring charges against the parents of a young child who had died in their care. I think the best way to talk about and read through the posts is to direct the court to pages 5 to 10 of the defendant's brief, if I could, and you'll see each of the defendant's 9 separate posts at pages 5 to 10 of that brief. And I'd like to start in particular with page 7 of the defendant's brief. At page 7 of the defendant's brief, it's the second post on page 7. The defendant makes the statement, the core statement that the state alleges is a threat in this case. And I'm gonna quote from that post. The defendant wrote, quote, "If our head prosecutor won't do anything, then the death to her as well," unquote. That is the core threatening statement that is at the heart of the state's case here. I think if you look at that statement alone in isolation, it's not entirely clear what it means. And so to have a full understanding of the meaning of the statement, you also have to look at some of the surrounding Facebook posts that the defendant wrote that night. And I want to point the court to 3 posts in particular that I think shed light on the meaning of this core threatening statement: if our head prosecutor won't do anything, then the death to her as well. The first post is at page 5 of the defendant's opening brief. And it's the very last sentence of that post. The defendant wrote, quote, "I hope those that are friends with her meaning the district attorney, share my post because she will be the first to go, period, and point made." The second post that clarifies, I think, further this comment, and again, that core threatening comment, the death to her as well, is on page 6 of the defendant's opening brief. And in particular, it's the defendant's statement that he would meet a law enforcement officer, quote, "with a shotgun pointed at him and an AR-15 in the other arm," unquote. And also the defendant's related statement in that same post on page 6 that, quote, "I would open every gun I have," unquote. And I think it's just worth pausing on that sentence and reading it one more time for emphasis. "I would open every gun I have." The final post that I want to direct the court's attention to, that I think again sheds light on this core threatening statement, the death to her as well, is on page 8 of the defendant's opening brief. And it's the second post on page 8. The defendant says, quote, "It is up to the people to administer justice. I'm always game to do so. They make new ammo every day," unquote. I think if you take those 4 posts together, they convey to a reasonable person a serious expression of an intent to engage in an act of unlawful violence. That's the key test under the First Amendment that we're asking the court to apply here. It is an objective test. It's a reasonable observer test. It looks at the text of the allegedly threatening statement and its surrounding context and asks, what does a reasonable person, a reasonable speaker of English, familiar with these statements and their full context, understand the statements to be saying? And our argument is that these 4 statements that I've just walked through are sufficient to amount to a true threat under that objective standard.
Counsel, while our minds are fresh on these particular Facebook posts, what's your response to the defendant's position that this is just really political hyperbole and that this is more of a comment by the defendant on the system itself, and that a statement such as the DA needs to be the first to go would be her political defeat, and that the justice system just needs to be changed, and therefore death to it means a change of it as it exists?
Your Honor, there's no question that there is political speech in some of these posts. I don't dispute that. I don't think anyone could dispute that. I think anytime you have a threat involving a public official, it is going to involve some political speech. And I think the hard question that these kinds of cases raise is, when do you cross the line from hyperbolic, vitriolic political speech, which is unquestionably protected by the First Amendment? When do you cross the line from political speech into threatening speech? And so although I agree that there is some political speech in these posts, I don't think that's enough to immunize the statements that I just read, which I think in context convey a serious intent to engage in unlawful violence. I think the question that every jury and every court is going to have to confront in these cases is how to draw this difficult and challenging line between protected political speech on the one hand and unprotected threats of violence on the other. I think maybe another point that comes into play here is the standard of review. We're asking for the court to apply an ordinary sufficiency analysis here to decide whether there is enough evidence in the record to allow the state to retry the defendant before a properly instructed jury. And under the sufficiency of the evidence standard, as I know the court is well aware, the court takes the evidence in the light most favorable to the state and asks whether any rational juror could find the essential elements of the crime beyond a reasonable doubt. And I think applying that standard here in particular supports our argument that there's at least enough in these posts to get a rational juror, one rational juror, to believe that these are genuine threats.
Let me ask you about the standard of review. I think in your brief you indicated that the independent review discussed in the Bose case is to be treated as a supplement to the ordinary standard of review. Can you explain how the state would imagine that would work? Do you do it after you do the regular sufficiency analysis, or how does that work?
Yes, Your Honor. I don't think that the cases are exactly a model of clarity on this point. As I understand Bose, a court is first conducting an ordinary sufficiency analysis. That's step one. And then a court, it's kind of like checking your math after a complicated algebra problem. You're going back and you're making sure that because there are First Amendment values at stake, you haven't reached a decision that is infringing on protected First Amendment speech. It's kind of like a check or a backstop to make sure that the jury verdict complies with the Constitution. That's my best understanding of what Bose meant.
Well, how would you, let me just ask one more quick follow-up. How would you imagine that you don't infringe on First Amendment speech while taking the evidence in the light most favorable to the state? And do you understand my question?
I think so, Your Honor. I think the sufficiency analysis is always going to be the starting point. And I think what Bose is imagining is that there might be a case where after you conduct an ordinary sufficiency analysis, you might reach a conclusion that even if a rational juror could find the elements of the crime beyond a reasonable doubt, that would nonetheless be a First Amendment problem, because you, as an appellate court, as a reviewing court, exercising your own understanding of the Constitution, think, no, this would be a bridge too far. I think that's what I mean when I say independent review is something like a check or a backstop to make sure that you're not just rotely applying ordinary sufficiency standards, that you're applying those standards with First Amendment values in mind. That's my best understanding of what the doctrine actually means in light of the U.S. Supreme Court's decision in Bose. And again, I acknowledge that that decision is not a model of clarity. I think courts across the country have really struggled to articulate in a coherent way what independent review actually means. I think whatever independent review means, it is not.
Well, let me take another stab at the question that I think Justice Hudson was trying to ask you. Here we've got a specific statute that doesn't incorporate a true threats test into the statutory language. So given that the state concedes that in order to be punishable under the statute, the conduct in question also has to amount to a true threat. So walk me through how you would do this independent review analysis in a situation like that, where you've got both a statute and a separate true threat analysis requirement.
Your Honor, as you said, the state has acknowledged that the statute here has to be read in light of the First Amendment. And so the statute has to be read to incorporate the true threats test under the First Amendment. And so the question here is a pure question of constitutional law. In answering the constitutional question, in deciding whether there is enough evidence to satisfy the First Amendment standard, I think you would take it in two steps. At step one, you would conduct an ordinary sufficiency analysis just like you do in every criminal appeal. And then at step two, you would consult broader First Amendment principles. You would consult cases that say, for example, that core political speech is protected, that even when political speech is hyperbolic or vitriolic, it is still nonetheless protected. You would take care to make sure that you're not applying a rote sufficiency analysis. I take that to be the gist of what the U.S. Supreme Court is saying when it's talking about independent review. I think whatever independent review means, it is not what the Court of Appeals did here. And this court's recent decision in Desmond, I think, is very, very helpful on this point. At footnotes 16 and 17 of Desmond, this court set out two key limits on independent review, both of which the Court of Appeals exceeded here. The first limit is that in Desmond, again at footnotes 16 and 17, the Court of Appeals said that you still apply ordinary sufficiency standards, that independent review does not displace these very familiar standards that appellate courts use all the time to review the sufficiency of the evidence. And I think that's one of the core errors that the Court of Appeals made in this case. If you look at the sufficiency analysis the Court of Appeals did here, and that's at roughly pages 80 to 105 of the Court of Appeals' slip opinion, you will not see any mention of the relevant sufficiency standards. You will not see any mention of taking the evidence in the light most favorable to the state, or asking whether any rational juror could find the essential elements of the crime beyond a reasonable doubt. So I think that's the first way in which the Court of Appeals exceeded the limits on independent review that are set out at footnotes 16 and 17 of Desmond. I think a related error, I think this is the second key limit on independent review that Desmond articulates, is independent review is not a license for an appellate court to second guess the credibility of witnesses. And I think that is what the Court of Appeals did in this case. I think the Court of Appeals used independent review to second guess the credibility of witnesses. And let me give you two concrete examples of that from the court's discussion. If you look at page 92 of the Court of Appeals' slip opinion, the court reached the conclusion that the district attorney here showed only a low level of concern about the Facebook posts. And it reached that conclusion because the district attorney decided to go back to work, to go back to her office building the next day after these threats were made. The court appeared to fault the district attorney for going back to work and then in the process apologizing to some of the security officers who were at the courthouse who showed up in extra force the next day to make sure that she was protected. That's what a leader does. A leader shows up at a moment that's difficult, at a challenging moment like this, when there's been a serious threat on the integrity of the justice system. And I think by criticizing the district attorney for appearing at work and apologizing to security officials, the Court of Appeals below was essentially criticizing or second guessing the credibility of the testimony of the district attorney in this case. The Court of Appeals was saying, even though the district attorney described all of these ways that she took the threat seriously, we just don't really believe her because she showed up to work the next day and was apologetic to the security officials who were defending her. I think that's one example. The second example I would give you is at page 93 of the slip opinion, where the Court of Appeals wondered why it took the SBI an extra day to start an investigation in this case. The posts were made by the defendant between 5 and 6 p.m. at night, and the SBI interviewed the defendant the next day in the early afternoon. The Court of Appeals seemed to suggest that that amount of time was just too long to suggest that the SBI was taking these threats seriously. And again, I think that essentially amounts to an attack on the credibility of the SBI. The SBI sent 2 investigators to speak with the defendant the very next day after these posts were made, and they were made later in the evening. So I think that is another example of how the Court of Appeals exceeded these 2 key limits on independent review that were articulated by this court at footnotes 16 and 17 of Desmond.
Let me ask
So
a
is
quick
that-
question. I'm
Go
sorry,
ahead,
Justice
Chief. Go
Hudson.
ahead, Chief. No, go ahead, Chief.
Well, I was going to go in a little slightly different direction. So if you've got a question about what he asked, Justice Hudson, that'd be fine.
I was going in a slightly different direction too, so go.
Okay. All right. Well, I'll begin the slight detour. So in the world of dinosaurs, we use paper, and you write a letter. Let's say that you're emotional because of something that's happened. You write a letter. Even if you stick it in your mailbox, next morning you go, oh, what was I thinking? You retrieve the letter. How do you retract a Facebook post? And how are we to consider technology in this context? And how should we consider the immediate or very quick removal, is up for, I guess, an hour before it came down. How do we consider that in this analysis?
Yeah. So let me start with the broader question of how you think about technology, and then let me try to answer the more specific question about, what do you do with the fact that the defendant took these posts down pretty quickly after they were put up? I think on the broader question about the effect of technology, I think there's no question that more of us are living more and more of our lives online, and that more and more of our speech is recorded online in a way that is visible not just to our friends or acquaintances, but to everybody. And I think that the online nature of speech in this case, or in any other case, is a relevant objective factor that a jury can consider, that a court can consider when conducting appellate review. I think it cuts in both ways, though, because social media platforms have a unique ability to facilitate violent threats and to accelerate violent threats. I mean, I think we've all seen examples of how speech online can spin out of control. And so while I'm sensitive to the fact that, again, more of our lives are being lived online, and individuals are making more and more statements online that can be recorded and looked back on, at the same time, social media platforms do have a uniquely pernicious ability to facilitate violent and threatening speech. On the particular facts of this case, I believe that a jury could take into account the fact that the defendant took these posts down roughly 2 hours after they were put up. I think the testimony in the trial record is that the posts were made between 5 and 6, and the defendant took them down sometime between 7 and 8. And I think it's laudable that the defendant took them down. The defendant here also apologized on a number of different occasions to the district attorney. I think that's also laudable. But these posts were up long enough for all of these things to happen, for the SBI to get involved, for security at the courthouse to increase, for the district attorney to take down an online video of her home. And so the horse was sort of out of the barn. The damage was done. I mean, these were up long enough for harm to be caused, for reasonable people familiar with the full context of the post to understand them as serious expressions of an intent to engage in unlawful violence. I can imagine another case.
Sorry, I know, I'm sorry to interrupt you, but the
That's
time.
okay.
And it seems to me that this point relates to the question of whether or not there should be a requirement of proof of a subjective intent to threaten. And my question is that the defendant says that it's actually often and most usually going to be pretty easy to prove that there was a subjective intent to threaten, and that but that it is an important element of the crime. And why in the state's view is it such a problem that we should also have to prove a subjective intent to threaten?
Your Honor, I think that's an empirical question about how easy it's going to be for the state to prove subjective intent. I don't really know. I mean, I think there may be cases where the evidence of subjective intent is plentiful. I think there will certainly be cases where defendants come in to court and testify that they were just joking, or they were blowing off steam, or they were trying to engage in artistic expression. And that kind of testimony, I think, will make it harder for the state to prove subjective intent under those kinds of circumstances. I think in our view, the objective standard is the only standard that makes sense here, because true threats cause harm because of their effect on listeners. They cause harm because reasonable people understand them to be expressions of impending fear and violence. It doesn't matter, for example, to an elementary school student who's fleeing her classroom after a bomb threat, what's going on in the defendant's mind. It doesn't matter to her parents who are trying to contact school officials. It doesn't matter to the police officers who are trying to secure the scene. What matters to all of those people, what matters to all of us, is the objective understanding that reasonable people have of what a defendant says. And I think that's why a purely objective standard should be applied here. I think a purely objective standard also, by the way, and I know I'm eating into my rebuttal time a little, but just one more point on this. I think a purely objective standard also provides sufficient safeguards to protect core political speech. This is not a slack standard. It requires the state to prove beyond a reasonable doubt before a properly instructed jury that a reasonable person familiar with the context would understand the statement as a serious expression of an intent to engage in unlawful violence. That's a hard standard. That's a burdensome standard for the state to have to prove, and I think it will sort out core political speech or artistic expression or other types of speech that really should be protected under the First Amendment. And with that, I'd like to reserve my remaining time. Thank you.
Thank you. Thank you, counsel. We'll hear from the appellate.
Good morning, Your Honors, and may it please the court. My name is Aaron Johnson, and I represent David Taylor. And I would like to start off with the issue you all were just discussing, the question of subjective intent. And in particular, I would like to take what appears to be my first opportunity to respond to an argument the state raised for the first time in its reply brief. And this is the argument that recognizing a subjective intent component to the true threats exception would somehow make that exception an outlier or anomalous or somehow out of sync with the way we treat other categories of unprotected speech. I think that argument is mistaken, so let me point out why. Start with Alvarez. That's the stolen valor case from about 8 or 9 years ago. And that case has the most comprehensive list I've seen of the different categories of unprotected speech. And if you go through the categories listed there, they break down into 3 groups more or less by theme, by content. And there are the exceptions that deal with sex, the exceptions that deal with lies, and those that deal with violence, real world physical violence. And in the violence group, there are 3. There are true threats, which we're dealing with here. There are fighting words, and there is incitement. Now, fighting words, I think, is of pretty low relevance, given that I don't think the Supreme Court has ever actually upheld a fighting words conviction. So that leaves us with incitement for some guidance. And incitement does include a subjective intent component. To be incitement, the speech at issue has to be intended to incite imminent lawless conduct, and it has to be likely to have that effect. So recognizing a subjective intent component to true threats won't make this category of unprotected speech an outlier. It'll keep it consistent with related categories of unprotected speech.
Well, what do you say about the state's argument that what matters is the effect on the listener? That's really the most important part.
That is part of it, but that is not the full story. If you go to cases like Virginia v. Black or RAV, they actually list 3 different purposes that animate the true threats exception. One of them is preventing fear. One of them is preventing the disruption caused by that fear. And one of them, the third, is to prevent threats from turning into actual real world physical violence. And that's the part that I think connects most directly with the subjective intent component. Because I think it's unlikely that a speaker is going to act on a threat that they didn't intend to make. And so that's why I think we can resolve the subjective intent question. You don't need to take such a broad view of the different categories of unprotected speech. I think you can get there with Virginia v. Black, which remains the controlling case on this issue. Within that opinion, both the majority opinion and the plurality talk about the speaker's subjective intent. The definition in the majority portion refers to situations where the speaker means to communicate a threat. They describe intimidation in the constitutionally prescribable sense as intimidation, as speech that is done with the intent of placing the victim in fear. The intent is what makes it prescribable. And they make clear that the intent is to make the threat, to convey it, not necessarily to act on it. And
Well,
I think
if the threat is intended to, if the purpose of it is to convey that a concept of whatever the threat is, and that the result upon the listener is fear and disruption, isn't that the primary problem with a threat, is that it causes the fear and the disruption, that if it actually turns into violence, then it becomes a whole other category of offense?
well, it is that third purpose of the true threats exception that I was talking about, being able to stop violence before it happens, to nip it in the bud, essentially. And so you can think of examples, different types of threats. I think the state would actually agree with me on this, that there are types of true threats aside from intimidation. And so one of the examples that you see coming up in case law is where somebody is planning a violent attack, right? Somebody goes on a website like Stormfront and they're planning to commit some act of violence, and they're making threats there, but it's to recruit allies and not really to intimidate their target. So a situation like that would, I think, connect more closely with that third purpose that animates the true threats exception. Does that make sense?
Certainly you want to prevent violence from actually turning into a terrible event, but don't you also want to prevent the disruption and,
Yes.
you know, like a stampede or whatever, closing down of school or something from the communication of a threat that really is not intended to be carried out, but that listeners think is?
Well, I mean, that's why there's the objective test in the first place, to prevent the fear, to prevent the disruption, because if you have a statement that is secretly meant to be a threat, but it doesn't come across that way, then that's not going to lead to the sort of fear and disruption that you're talking about, which is why there needs to be both the subjective component and the objective component.
Well, isn't there also a countervailing interest protected by the First Amendment, that the true threats doctrine exists to give expression to, and that is, so in other words, a subjective intent requirement helps serve the First Amendment purpose or value of allowing political speech.
Mm-hmm.
And does it also, does the subjective intent requirement go to the issue of culpability, right? So on the one hand, we want to protect the public and don't want fear to be caused, but on the other hand, it seems to me you want to protect people's right to speak and criticize the government, and only punish behavior that someone intended to, where someone intended to threaten someone.
Yeah, I think that's absolutely right. And are you thinking about Alanis?
Well, I think there's a couple of cases where the U.S. Supreme Court has talked about the First Amendment value and the importance of erring on the side of protecting political speech in particular.
Yes. Yes, and I think Alanis also speaks to this. The state is right that Alanis was ultimately a statutory interpretation case. But the point I'm trying to make with Alanis is that if criminal law in general requires more than a negligence standard, then so should the First Amendment. So, and I think
Mr. Johnson, this may be as good a time as any to follow up on some, at least of where I think Justice Earl's question was headed. I don't really like to get into circuit counting or, counting the decisions one way or the other by courts across the country, but both you and Mr. Brode have done some of that in your briefs, and I'm interested in your perspective of, is there a predominance of decisions with respect to this subjective intent versus no subjective intent element one way or the other as you view it?
Yes, there is. Most jurisdictions that have considered the question, even following Virginia v. Black, have required only an objective showing. But the trend has been in the opposite direction.
And why do you say that, just so I'll understand?
That the trend is heading the other way?
Yes, I'm sorry.
That's in recent years, in particular with cases like Castle in the Ninth Circuit, which was followed up more clearly by Bagdasarian and Heinemann out of the 10th Circuit, which has probably the best analysis of Virginia v. Black that I've seen. But some courts started to figure it out fairly early on. The 7th Circuit in cases like United States v. Parr, though they didn't ultimately have to resolve the question there because the jury in that case had been instructed on a subjective intent requirement. But the state is correct that the majority view does still require only an objective showing.
Okay, thank you.
Let me back up, and I'm sure you were going to get to this at some point, but ask about the standard of review. The state has argued that you don't want to scrap the traditional standard of review in a criminal case, in that you look at the evidence in the light most favorable to the state, determining whether a rational juror could find certain facts, and then add to that sort of a backstop, as he puts it, or kind of a supplemental review to make sure that you're not unduly infringing on First Amendment principles. What do you say about that potential approach? And I don't see any authority for scrapping the traditional sufficiency of the evidence review. Do you?
The answer is, after reading Desmond, I do not see a lot of daylight between sufficiency review and whole record review, and I would very much like to be wrong on that.
I appreciate the candor.
Yeah.
Well, is it, because this is the version of the question I asked Mr. Brode too, given your understanding of how this independent review is to be conducted in light of the authorities that are discussed, including Desmond, what should a reviewing court do to conduct an adequate independent review in a case like this one, where you've got a statute that doesn't specifically incorporate a true threats element, but at the same time, the Constitution requires a showing of a true threat in order for a guilty verdict to be consistent with the Constitution?
Well, I think it should be more or less an independent review of the full underlying record, while deferring to the finder of fact on questions of credibility. And I do think that last part is important, because if you have some witnesses saying X and other witnesses saying not X, two different sets of testimony or evidence that are just mutually inconsistent, then the analysis couldn't even get off the ground. but I do think it should allow an independent review of evidence that is undisputed and the ability to draw inferences that are the most reasonable under the circumstances, even if it's not necessarily always in the light most favorable to the non-moving party. But I understand that does require viewing the evidence in the light most favorable to the non-moving party.
I believe that the Court of Appeals decision in this case antedates Desmond. You may be wrong about that, but I think that's right. In your view, is the Court of Appeals independent review in this case consistent with the approach adopted in Desmond?
I think the state is correct that there are a couple of places where the analysis does not necessarily take the evidence in the light most favorable to the state. And that's regarding how seriously DA Welch took the threats, though I do think that a fair view of the evidence would describe the reaction as modest, because they did basically three things to increase security, right? They added a few deputies around the courthouse. They took down a video that showed the inside of her home from a real estate website. And she stopped going through Mr. Taylor's building as a shortcut to lunch. But she still came into work. She actually lived alone, and when they offered to send deputies out to make sure she was okay, she declined that offer. She continued using the shared smoking area. So there was some concern, but I don't think anybody panicked.
Well, just so I understand, in your brief, and again in one of your answers to me, you made a distinction between direct evidentiary conflicts and inferences. I mean, one of the issues in this case appears to be, what was Ms. Welch's reaction to the threats. You recited evidence that, at least is in terms of discrete evidentiary facts about what Ms. Welch actually did. Is it your contention that a reviewing court conducting independent review is entitled to decide which view of those evidentiary facts ought to be adopted, even if the jury went the other way?
I think there's a little more freedom to do that when you have a case like this one where the jury is not properly instructed, and so you don't have clear findings about what they actually had to decide, if that makes sense.
It does. I mean, I think that's helpful, yes.
Okay. But either way, I'm sorry, was there another question?
I was about to jump in, but go ahead and complete with your thought.
Oh, okay. I was about to move on to our sufficiency argument.
Okay, well, before you move on,
Yes.
since we were talking about a reviewing court's proper direction in the defendant's view, where would be the line as far as where it's properly placed between a prescribable threat on one hand and the protection of someone such as your client's rights under the First Amendment in light of what a reviewing court should consider, especially as to the application of independent review?
Okay, let me see if I understand the question. Is it about what constitutes a true threat and how the appellate court should determine whether the evidence is sufficient to make that determination?
Well, I'm putting in, as much as I can, a quantifiable way what opposing counsel and I addressed early on in terms of talking about how you've got this mixture between political speech on one hand and on the other hand, what could constitute a true threat, especially in light of what you said about Ilanis, that the reasonable person standard doesn't apply. So looking at it from that standpoint, as best you can determine what I'm trying to ask, you've got a prescribed threat which ought not take place. But then on the other hand, you've got the protection of the First Amendment, which would be afforded to a commentator. Where do you feel the line should be drawn by a reviewing court?
Well, on the one hand, I think the state probably is correct that speech is protected up until it crosses the line into a true threat. But the concept of true threat, that category of unprotected speech, needs to be kept within sufficiently narrow boundaries in order to afford protection for other types of speech, including political speech, which is why we're arguing that both case law and broader First Amendment concerns require both an objective showing, that is, that a reasonable person familiar with the full context would treat that statement as a sincere threat of unlawful physical violence. That's kind of a mouthful, but the gist of it is that the heart of a true threat is it has to look like the speaker is really going to act on it.
Well, it sounds like you may be saying then that there is a place for the reasonable person standard.
Oh, yes, absolutely. There is a place for the reasonable person standard. There needs to be an objective showing and a subjective showing that the defendant subjectively intended for their statement to be understood as a threat. And the strongest support for that in the case law is Virginia v. Black. Both the portions of the majority opinion that provide a definition of true threats and the portions of the plurality opinion that apply it. At issue in that case, and I think this is significant, is they were dealing with a state cross-burning statute. It barred cross-burnings when done with the intent to intimidate. The problem was that there was a separate provision that allowed the jury to infer intent from the bare fact of any cross-burning. And so if you go towards the end of the plurality portion of the opinion, and if it's okay, I would just like to quote that part. The prima facie evidence provision in this case ignores all of the contextual factors that are necessary to decide whether a particular cross-burning is intended to intimidate. The First Amendment does not permit such a shortcut. Now, if the First Amendment did not require a showing of subjective intent, then a shortcut to proving that intent should not be a First Amendment problem. Now, since I still have some time left, I think that brings me to our second issue, and that's whether under whole record review or a normal sufficiency.
Yeah, before you get there, just very quickly, it seems like to me that the court, the trial court, we, the justice, we've got kind of a gatekeeping role. What's the balance, or where do we draw the line with that gatekeeping to, one, protect what could be considered predominantly political speech that maybe has some elements of a threat? I guess in some ways this has to do looking at it like most favorable to the state versus, help me understand where we, the court, say this is just not enough to get it to a jury.
Do you mean the role of the trial courts, or do you mean the role of our appellate courts?
Well, right now it's the role of the appellate court to instruct the trial court, and we will do so either by saying there's not enough evidence here to retry it or inadequate, or it's protected by First Amendment, or we're going to say retry it. So as we're trying to figure out where that line is to say there's too much, do we look at the go through line by line and say political, potential threat, how do we do it?
Well, I mean, I do think the inquiry has to look at the speech in full context. I think that that's one of the issues where there's really not a lot of dispute between Mr. Taylor and the state. Whether in light of the full context and the full existing record, a reasonable person would think that the statement seriously expresses an intent to engage in violent, real-world physical violence. The state was saying earlier that that's an appropriately high standard, and I agree that it has to be a high standard. So that would be the role of either the trial court or the appellate courts, I think, to make sure that there's sufficient evidence in the record where a finder of fact could make that determination beyond a reasonable doubt. That is, in a case like this one, they would have to be fully satisfied or entirely convinced that this is not just political rhetoric. And on this record,
in his concurring opinion, Judge Dietz talked about death to the system and then death to the DA. Do we take a phrase like at what point it's the jury's role versus at what point it's the court's role to say that just given the context is political.
I think Judge Dietz's concurrence was entirely correct on that point. That in the modern English language, calling for the death to something is a non-literal or a figurative call for the downfall or ruination of that thing. It's not actually calling, and I think that in this case here, you have the two different uses of it that sort of pair them together, right? Because at one point, Mr. Taylor said, death to our judicial system because it only works for those that are guilty. And then later on paired it with the death to D.A. Welch. And so I think when you look at those two together, especially, along with all his comments about political nonsense, that it was very much like the defendant's statement in Watts, a crude, offensive way of stating political opposition to the district attorney.
The Court of Appeals also pointed to the fact that it was a couple of the statements were conditional. You know, if this, then, and how does that weigh into the calculus of the sufficiency of the evidence?
Sure, that's definitely part of the totality of the circumstances test. And I think that it depends on how likely that condition is to come to pass, if that makes sense. Threatening somebody like, you're going to have trouble if I see you around here again, is probably a more serious threat than if the revolution ever comes, you'll be the first to go. Because in the first example, that's a much more likely condition to happen. And in the second example, I don't think there were any indications of revolution in Macon County in 2016.
Is there a tension here? Is there some tension between the application of Elanis and the application of Black as applies to this case? I was somewhat convinced that your position coming into this was, as I looked at your brief and the state's brief, that the defendant was not inclined to feel as though a reasonable person standard had any place here at all, because of the fact that there should not be a negligence aspect to the application of the statute as Elanis represents, and that you were relying most fervently on Black. But I think I'm hearing a mixture of both, and yet I want to make sure that I keep the context of both intact. If you are, for the defendant, finding that there are features of each one that should apply here, instead of just all Black and no Elanis.
Okay, my apologies if I've been unclear, but let me make this, I'll try to be as clear as I can. We're asking for the application of both a subjective intent component and an objective component. That is, the statement would have to be one that a reasonable person familiar with the full context would interpret as a threat to engage in unlawful physical violence. The other component is that the defendant subjectively intend for their statement to be understood or interpreted as a threat.
So in figuring out how that would go to the jury, would you contend that each of those should be separately submitted as elements to the jury?
Yes, absolutely.
So the jury could find that a reasonable person would believe this to be a real threat, but if he didn't actually personally intend to carry it out, he would still be acquitted?
Well, close. The intent is not to act on it. The intent is to convey a threat, for the statement to be understood as a threat, whether or not the defendant intends to act on it. But yes, I think the jury would have to make both of those findings to have a valid conviction.
Okay.
Mr. Johnson, you mentioned Elanis and you mentioned Virginia versus Black. My reading of the dissent, Justice Thomas's dissent in Elanis, It sounds to me like he's interpreting Black to not require subjective intent, but you think that it does. Could you help me reconcile those points?
I think that Justice Thomas is incorrect on that, and a couple of the different justices have sort of publicly staked out views on this. Justice Thomas has taken that position. Justice Sotomayor, on the other hand, expressed her views that a subjective intent requirement is been imposed by Virginia v. Black and to a lesser extent by Watts, and that was her concurrence in the denial of cert, and I think it was Perez.
It was Perez. Can you elaborate in any way?
Sure. On why Virginia v. Black requires a showing of subjective intent? Yeah. There's the definition in the majority portion of the opinion that talks about what the speaker means to communicate and describes intimidation as having a component of intending to place somebody in fear of bodily harm or death. But then there's the plurality opinion that I think shows this just as clearly. I spoke about that a little bit earlier, but there's another portion of the plurality where they talk about cross burnings being done for different purposes. And they say that if a cross is burned for the purpose of expressing a political or ideological message or some sense of in-group solidarity, then that would be protected. Whereas it would not be protected if it were done with the intent to intimidate. So if the exact same communicative act can be a true threat if done for one purpose, but not a true threat and protected if done for a different purpose, then that means that the speaker's subjective intent is a necessary component of a true threat.
But sir, couldn't it be explained by the context, the objective context of how it was conveyed?
Not for something like cross burning, which is why I think the subject matter was significant. Because if you had somebody burning a cross at a political rally that was still that was visible to the public, and that was one of the scenarios that they dealt with in Black, I still think that the speaker would be reckless regarding whether the audience would take it as a threat, and probably in most cases they would know. And yet the plurality still said that the act of burning a cross under those circumstances would be protected speech.
Thank you.
Okay. Well, it looks like I'm running low on time. So on the sufficiency issue, I suppose I'll have to rest on the brief. And if there are no further questions, I'll ask this court to affirm. Thank you.
Thank you, counsel. Rebuttal.
Thank you. I'd like to make two main points with my remaining time. The first point that I'd like to make is about Virginia against Black. And then the second point is just a broader point about the context of this case and the issue of subjective intent. On Virginia versus Black, the state is in large agreement with Justice Thomas's dissent in Alinus in that case. For the reasons that he explained, Black just doesn't answer the question here. The statute in Black had a subjective intent requirement built into it as a matter of state law. And so the court in that case didn't have the need or the opportunity or the occasion to decide the broader question here, which is whether every single threat statute across the country has to have a subjective intent requirement as a matter of federal constitutional law. I think the other key difference between this case or this issue and Black is that the statute in Black had a constitutional problem because it didn't sort objectively threatening statements from statements that were protected political speech. The court had a concern with the statute in Black because a reasonable person viewing a cross burning in context as part of a movie or a play, for example, could nonetheless have convicted a defendant with a crime under that statute. That was the problem with the state law in Black. And so the court just didn't have the opportunity on the unique facts of that case to address whether subjective intent is always required under every single state law that attempts to criminalize a threat. I think the subjective intent issue is a tough issue. As my colleague on the other side and Justice Ervin were discussing, it has generated a circuit split. I think there are good arguments on both sides. I think if the court takes stock of this issue and decides that it doesn't want to wade into the circuit split or pick a side, I think there is enough evidence on the record here to allow us to get to a retrial, even if we were required to show subjective intent. I think the state at trial admitted enough evidence of the defendant's subjective intent in order to get a retrial. And for those reasons, we would ask the court to reverse. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court. All right. Thank you, counsel.